Thank you very much, and I hope I'm clearly audible. Thank you also for your kind introduction. Thank you for all the people who are delegates listening in today. Thank you, Sean, for your opening remarks. Might I just say, just by way of a very quick commentary, that I think the traditional view is that the enactment of criminal laws that are fair, clear, and coextensive were primarily considered in the context of society's interests because of the traditional 17th century onwards view that crime is a legal wrong punishable at the instance of the state. But it's quite clear from European human rights law and also from law that has been adopted by the administrative courts, and particularly by Justice Steen in the United Kingdom, around the fact that we now have to consider our criminal justice system in terms of a tripad of interests, that is the interests of the accused person, the state, and the victim. And that's the part of the equation that's often forgotten. And that's what I want to address today. So just to bear with me while I share my screen. Hopefully it is there now. I can't see at my end. That's rather unfortunate to see what you people can see. Right, so I've called my presentation Lost, Found, Amplified Victims of Crime. And my underlying theme is that access to justice is not the same as the right that is often recognised in charters or declarations. That is, that it says that victims have access to the mechanisms of justice. But what happens if those mechanisms are unjust, if they are unfair, if they do not meet the needs of victims of crime? And that, for me, is one of the most important issues that's often forgotten, is often lost in the debate about procedural justice and ultimately justice as an outcome in our system. So just bear with me while I very quickly move through a series of slides before I get to my key point. So why did I call this Victims Lost in the first place? Well, if we take a very rose-tainted view of the early criminal justice systems, whether it begin right back at the Code of Ipswich or the Code of Hammurabi, Anglo-Saxon law, or even some of the early laws after 1066 with the Norman invasion of England, then we can see that the victims played an integral role in the criminal justice system. They got to make the decisions that affected them. And often the role of the state was perceived as providing a mechanism within which conflict between the person who perceived themselves as the victim and a person who was the accused could resolve that conflict without the vested interest of the state. But over a period of time, that interests became subordinate to those of the state. And ultimately, for a number of reasons, the interests of the state became paramount at the expense of the victim in particular. The victim's interests were relegated. And that's why I say that by the time we get to around the 18th or 19th century, a victim's interests have largely been lost. And it's not until the late 1950s, early 1960s that we really begin to get a conversation about victims being found. And that's largely a consequence, might I say, of the women's movement and their advocacy around the needs of victims of sexual offences and victims of domestic and family violence. I want to make the point that it's interesting that one of the earliest common law jurists, Blackstone, said that whenever a crime happens, there are in fact two victims, the actual individual who has been wronged and the state. So even in the earliest discourse around the common law, which countries such as, or places such as Northern Ireland or my home country of Australia, as in my home country now, have inherited, the idea that there are two victims has been lost. And that loss has been particularly most profound since the establishment of state-funded police forces and ultimately Crown prosecution services. My next point, and I'm sorry that this is somewhat rushed, but I need to get through to in some 20 minutes or so. So my next point is that elevating victims' rights became an issue in the 1970s and 1980s when victims were once again found. And they were really found as a consequence initially of a discussion about the role in sentencing for victims and to what extent should a court attempt to right the wrong that had been done to a victim. And Margaret Fry, the famous English magistrate, argued that we ought to legitimise restitution, rediscover restitution as a sentencing option. And she then realised that many of the people that the police are most successful at capturing and prosecuting are those people who are least able to afford restitution. And so recognised that the state had a role in providing some form of compensation. And both restitution and compensation are recognised in international law and many victims' charters as being a fundamental entitlement for victims of crime. I want to make the point, and this photograph hopefully shows that, is that I'm an advocate for a parallel system of procedural justice. I think we can advance victims' rights, including giving victims an amplified voice through provision of legal counsel by having a parallel system of justice that doesn't unduly impact upon the rights of those people who are presumed to be innocent. We don't want to make victims of oppression. What we want is that the victims of crime get, for example, a say over the key decisions that affect them, and that say is done in an equitable manner. And if that means that they have legal counsel to help amplify, help barrack for them, then so be it. We should make space for them in our criminal justice system for that to happen. In my home state, victims have a number of rights. They have some 20 rights. They're enshrined in the Victims of Crime Act. What I find interesting is that we refer to them as victim advocates, as rights, but and that's what they used to be called when they're in administrative charter. But as soon as they were put into law, they became principles that govern the way victims should be treated. They became principles that govern the way that victims should be treated because the legislature and the powers within police and prosecution and so on did not want the obligations that go with rights. Because when a right is created, it suggests that those people who are obliged owe something to the victim. And this is most manifest, for example, in the fact that very rarely anywhere in the Western developed world do we see that victims' rights are mandatory. Do we see that it is mandatory to tell victims that they have rights? Instead, we have these proclamations and we hope, for example, that victims who want to know something about the progress of the investigation, if they ask, know that they have that right and they know that they have to ask before they become involved and get the information that they seek. In my home state, victims can be involved in bail hearings to the extent that a police officer or a prosecutor must now ensure that the victims concerned for their safety are presented to a bail authority, whether that be a senior police officer or a court. But how does that information get gathered? How do we ensure that that happens? Victims have a right to know what charge is going to progress, and if it's a serious offence, the right to be conferred with or consulted before a decision is made. And I find it interesting that a person accused of a crime is entitled to legal representation. The state is entitled to legal representation during those negotiations, but the victim is not. And prosecutors often tell victims that they are not their lawyers. How is that equitable? How is that fair? When it comes to debates in court about victims' privacy, for example, access to their private conversations between a therapist or a psychologist or someone similar, which in sexual offence matters is protected, but in other matters may not be as well protected. Victims have a right to privacy, but who's going to argue that for them when the obligation on the prosecutor is primarily to ensure that the interests of the state are done and that the court doesn't err in terms of its obligations towards the person who's accused? And we can say the same with the victim's role in sentencing. Who helps amplify, who helps put their voice, who helps give strength to their voice when a prosecutor is standing before a court and attempting to ensure that the court doesn't err in sentencing, when the defence are standing and arguing that this person's had such a terrible childhood, etc., and so therefore trying to mitigate the sentence. Or what happens when it comes to the issue of restitution and putting a case for the court to consider restitution as a valid sentence. Who gives voice to the victims? At the moment, it seems to me, and it seemed to me in 12 years as the Commissioner for Victims' Rights in South Australia, that those voices were often buffered or moderated by other interests, and primarily the interests of the state. And we can say the same through a whole series of steps in the criminal justice system. And in my PowerPoint, and these points are emphasised, and I've made the PowerPoint available for those who are interested. They can contact the Victim Support in Northern Ireland after this seminar. Now, in South Australia, we have a rather peculiar law, and that's section, for those of you who are lawyers, Section 32A of the Victims of Crime Act, and it says that a victim can appoint an approved person to be their appropriate representative and exercise any of the rights which they have. And an approved person can include the Commissioner for Victims' Rights, who, as I said, was me for some 12 years, or another person that the Commissioner for Victims' Rights considers to be suitable. And often I use that provision to appoint legal counsel to represent the victims, to help amplify their rights. And for that purpose, my unit, which was myself and one other person for the state, and before anyone goes, wow, that's incredible, well, 2 people running an entire thing, I do point out South Australia's total population is 1.4 million people, and we cover an area about 5 times the size of the entire United Kingdom. So by volume, it's most probably representative to much of the resource you have in your home places. But I could appoint legal counsel, and I had about $250,000 Australian for the purpose of being able to fund legal counsel. And what I found was the best thing to do was to go to speak to the most experienced criminal barristers and the most experienced criminal lawyers and ask them whether they would be interested in representing victims' interests. And they often said yes, yes. And the key issue is why? They said yes, because they recognised that there was a need for there to be equity in our criminal justice system. If there is to be just outcomes, there has to be some equity in the system. And that you can't have equity if you have 2 out of 3 of the parties having legal representation, and the third, the person's actually wronged, the person against whom the assault has happened or against whom the property has been stolen, has no voice, or what voice they have is muted because of the position they occupy, and that is relegated to merely a witness of the state. Now, I do go into some more detail about the role of the Commissioner in the presentation that I have at hand up, but I do need to point out that the Commissioner for Victims' Rights in South Australia can, and the law says this quite clearly, make submissions in any proceedings to which those submissions are authorised either by the Victims of Crime Act or by any other piece of legislation. And for that purpose can do that in person or through legal counsel. And this is a unique piece of law to South Australia, but it is a piece of law that I advocated for in a former role. And fortunately, we had a government that was willing to embrace it and enact it. A government that believed that victims should no longer be bystanders in the criminal justice process. And I think it's important that people in public policy recognise that victims should not be bystanders. They are the wronged, they deserve a voice. So how might this be carried out and put into place? Well, for example, at the investigational level, as the Commissioner for Victims' Rights, I introduced a letter notification system. So every time the police apprehended someone and laid a charge, it generated a letter in my office, and we sent that out to victims right across the globe. So to tourists, to other people, saying, here this is the charge, this is the name of the accused, this is the court they're going to appear in their first hearing. And if you want to be involved from now on, here is the way that you do it. And these are the contact people that you need to make a contact with. When it came to charge bargaining, now we don't have plea bargaining in South Australia, but when it came to charge bargaining, that is determining what is the most appropriate charge based on the evidence that is available, victims have a right to be consulted before a decision is made to withdraw a charge or to vary a charge, especially if they're a victim of a serious offence, which in definition in the Act is there is none, but it does include things such as domestic violence and family violence, sexual offences, and most acts of violence and property offences where the sum of the property is about 2,000 Australian dollars or more. Now, as I said before, in this charge bargaining process, submissions are made to the prosecution by the defence counsel and the defender through the defendant's instructions, and the prosecutor representing primarily the state sits and weighs that up. But who gives voice to the victims? So I found that it was important to appoint legal counsel to assist victims if they wanted, and that is a key issue, if they wanted the counsel. This is about amplifying their decision, not replacing their decision, not disempowering them, but rather acting as a method of amplifying the decision which they want to make. And so therefore it was necessary to talk to them and give them the options and ensure that they understood what the implications of those options were so that they could make an informed decision. And in some cases, the withdrawal of charges didn't happen because after the victim had sat down and had a discussion. I remember one particular case, and I'm mindful of the time that I have, but one particular case involved about a 14 or 15-year-old young person who had been the victim of sex offences, and the parent, excuse me, of that person was so angry by what had happened that all they wanted was prosecution, prosecution, prosecution. I want this person locked up, put in prison. I don't want them ever out on the streets. And I appointed legal counsel to represent the young person, and the young person said, well, that's not what I want. What I want is this person to be corrected so that they don't go on and create other victims. And I want to get on with my life. The fact this person's been arrested and spent 3 months in prison, etc., is enough for me. So after I appointed legal counsel for the young person, the parent said, well, this is rather unusual. And for the first time sat down and had a conversation with their child. And as a consequence of that, supported the decision that was made. Now, it wasn't my decision. It wasn't a decision of prosecution. It was the decision of a victim whose voice was amplified and given an opportunity to participate in a key matter that affected them. And amplification is about empowerment. It's not about replacement. When it comes to criminal proceedings, we have appointed legal counsel to argue to prevent a stay of proceedings application. Excuse me. We have appointed legal counsel, I did anyway, to argue suppression orders, in particular suppression orders to protect children from being outed by the popular media. And we've also argued cases around protected communications where defence have attempted to get around the protected communications provisions that exist to assist victims of sex offences. The Americans often call them rape shield laws, but I think that minimises the importance of that particular law. When we get to sentencing, I've had legal counsel represent victims to make individual victim impact statements, not only in cases involving normal criminal prosecutions, but involving cases dealing with mentally incompetent offenders as well, because sometimes the victims feel uncomfortable about expressing their view or talking about how crime has affected them. Sometimes they're just not able because of their level of literacy or some other factor to be able to clearly articulate their feelings. And so it's important to do so. And we reached a point, in fact, in our court system where in the superior courts, they sometimes would say, Mr. O'Connell, as the commissioner, do you have something to say? Would you like to contribute? I got invited to sentencing circles for the purpose of representing victims' views and all sorts. So the courts began to embrace the fact that they were getting good, useful information presented in a way that they could cope with, because of the fact that it came through legal counsel or through someone who was aware of the legal system, able to construct an argument in a manner that fitted, for example, within the rules that govern sentencing in our state. And even post-sentence, I've appointed victims to, legal counsel for victims to represent them in arguments around whether mentally incompetent people should be released back into the community and under what conditions they should be released, or where accused people subject to domestic violence orders have actually applied 12 months or so after an order has been made to have that order revoked. And victims often don't understand, and particularly in domestic violence cases, they have moved on with their life. They've gone, they've found somewhere safe and secure, etc. They don't want the perpetrators to know where they are. And so giving them legal counsel allows them to maintain a certain level of anonymity and therefore protect them and ensure that their personal safety is maintained to the best that it can be. I reiterate, this is about amplification. And one of the things that this does as challenges is to think about crime, not just in the context of contest between the state and the defendant, but rather to think about it from the personal encounter from the victim and the offender, an unexpected personal crisis in the life of a person, and that person wants to have a voice in those key decisions that affect them, as evident from the comments that were shown before my presentation, from the quotes from the various victims themselves. So access to justice is what I'm talking about, not access to the mechanisms of justice, but access actually to justice. And that means that we need to improve the way that we provide for the procedural justice of victims, and that requires equity, it requires fairness, it requires the opportunity to have someone to barrack, to present their particular perspective in a manner that is equal to that we afford to the person who's accused and that we afford to the state at large. And my concluding comments are that, in my humble view, victims once lost, the cliche was that they were forgotten and relegated to witness of the state. They have now been found, and that although victims have a fundamental right to access the mechanisms of justice, that is not a right to justice, and that is something that we need to remedy. And in my humble view, this won't happen until we accept victims as genuine participants in our criminal justice processes, and we change the discourse about criminal justice, and we tackle the issue of the balance of power or the imbalance of power that currently exists in our system. And I remind you, as my final comment, that it was Martin Luther King who said that when justice is denied anywhere, it diminishes justice everywhere, whether it be in down under or up there on top in Northern Ireland. Thank you for the opportunity to speak today.
Michael, thank you very much indeed.